Hello and welcome to our Working in Australia Mobility Risk and Compliance webinar. We have a fair good number of attendees logged in, so we're going to make a start. To begin with, I'm just going to cover a couple of housekeeping bits and pieces. Hopefully you can all hear me well. What we are going to try and do is present a few areas today and leave some time available for questions at the end. One thing I want to mention really quickly is that, as many of you probably realise, we're in Melbourne and we are locked down. And when we planned this, we didn't plan to do it in lockdown. So we are doing this from home rather than from the office as we'd intended. We don't believe that's going to cause us any problem at all. We think we've done this before and we can do it again. But I'm just throwing that out there as a way of getting some preemptive sympathy. If we have any IT issues, you will know exactly why. Otherwise, as I think for those of you who have used the system before, there's a chat function that you can ask questions. And what we will do is we'll try and capture all those questions at the end of the session and deal with the ones we can deal with and take on notice the ones that need a bit more personal attention and sort of go from there. I would also like to say that this is the first of what we plan to be a series of webinars, and what we've tried to do over the next 6 to 12 months is pick up topics that we think are going to be relevant and timely in the context of working in Australia. Obviously, with COVID, we felt that immigration challenges and expat tax challenges were front and centre for a lot of people, so we thought we'd deal with those ones first. The next session that we're going to run is going to be on fringe benefits tax because we'll be coming into the FBT season. And then we will be doing a number of further sessions. I think we'll do at least one further session as a deep dive into some of the immigration matters because it is so complicated and it is likely to change reasonably quickly over the next year. We're also going to look at aspects of paying employees, rem and reward, pay compliance against awards and EBAs. So we've got a whole series of sessions laid out that we think are going to be valuable to people who are involved with employing Australians in Australia. So what we will do after this session, you'll get a link to the remaining sessions and the opportunity to register. You will also get the opportunity to give us some feedback about what you might like to hear and see in those sessions so that we can make sure that they're as relevant and tailored as possible. And so we're hitting the things that you want to hear about. So by way of introductions, my name is Ben Renshaw. I think you can see that on the screen. I'm a partner at BDO. I lead our people advisory practice from Melbourne. My own area of specialty and expertise covers expat tax, employment tax, and pay compliance, pay against award, rem and reward, those sorts of things. We have with us here, we're very lucky to have with us here, Maria Jockel and Rebecca Thompson. Maria leads our immigration practice. And Rebecca works in our immigration practice too. I'm going to leave them in a little while to give more detailed introductions about the work they do and how they do it, because they're much better placed than me to do that. If I just try and give you a very quick overview of what we're going to try and cover off today, the topics that we have in mind. I'm going to spend a few minutes on expat tax in the times of COVID, which is really some of the challenges that expats and cross-border employees are facing. Really things that clients are asking us about and areas of concern. I'm going to spend 10 or 15 minutes on that. And then we're going to spend the remainder of the time on immigration matters, really looking at the transformation of the management of the Australian borders in the context of COVID, how the Department of Home Affairs, Border Force operate and interface and work together in the context of exemptions, visas, data matching, which is very important and becoming more important, regulatory compliance, and then sort of as a consequence of all those things, if you like, what mitigation of risk to businesses looks like in this context. As I said, we'll then have some time for Q&A, and then we will wrap up. So I think the speaking portion of this webinar will probably take us between 45 and 55 minutes to complete, and then we've got plenty of time for questions afterwards if we need them. As I said, we're also happy to take questions that come through, take them back, have a think about them, and get in touch one-on-one where we can help, where it requires a bit more effort or work for us to help. So that's what we've got in mind. That's who we are. What I will do now is I will just kick off with some commentary on my core area of interest, if you like, expats and dealing with expats at the moment. And what I thought I might do is just cover off some of the areas that we're getting questioned on fairly extensively over the past 6-9 months, and some of the issues that these things throw up. So you can see here, I've said these are really things that clients are asking us about. So I thought if I put some of these things out there, it might be helpful to some of the people listening in. So the first thing that we're being asked about quite extensively, actually 6 months ago was more prevalent, but it still happens now. What we're seeing is senior executives who have been posted overseas, who are maybe in Europe or the US, have been accelerating, prioritizing, really focusing on returning to Australia. And it's for fairly obvious reasons. Obviously, the pandemic is much less under control in the US and Europe than compared to here. So senior execs are going, you know what, I was going to go home in the next 12 months anyway. Maybe now's the time for me to move my family back, move my role back, work back in Australia, even though it wasn't what I planned originally. So that's a fairly common question that comes up. And what tends to happen is it all happens fairly quickly. People make the decision, assuming they can get flights and get into the country, then it happens fairly quickly. And the last thing to think about are the tax implications. And there are some, right? So what with that, we have to deal with all sorts of things there around what re-becoming an Australian tax resident means for these individuals in the context of their REM, their maybe bonuses and share plans, deemed acquisition of assets when they become a tax resident once more, can all be quite complicated things to deal with. So in the ideal world, we would do a bit of planning with senior execs around, well, what's going to happen when they return? How is their salary going to be taxed? How are their bonuses going to be taxed? How are their share and equity holdings going to be taxed? And as I say, what does it mean from a capital gains tax perspective to be returning and becoming a resident again in Australia? And for those that don't understand, the residency tests in Australia are fairly facts and circumstances based. So they almost take a very general view of what living in Australia means. If you give up your home somewhere else on your assignment in Europe, you reset up your home in Australia, your family move back, you start to enroll in schools and all those things, you're going to be a resident again of Australia and be taxable here on your worldwide income for all the things we've spoken about. So the ideal there is to do a little bit of planning, as I said, around how those things are going to be taxed, where and when, and also to look at the other country as well to see what breaking residence in the other country looks like and what the trailing tax obligations there look like, just to make sure we can do any planning that needs to be done and make sure that the tax obligations and compliance matters match up as effectively as possible. As I said, it often gets left to the last minute because these moves can be a bit of a mad rush once the decision's made, but it's something that if you have senior executives moving back into Australia earlier than anticipated, it's really important for them that they do that planning piece. The other thing that happens in this scenario is that when individuals move back to Australia but carry on doing their overseas role, we can create some unintended Australian consequences as well. So if an individual is a senior executive of the Swiss business, but then keeps that senior executive role of the Swiss business, but performs those services from Australia, we have a whole host of potential risks that we're exposing the business to in Australia that may never have been relevant before. So all of a sudden, the Swiss business in my made-up example could have withholding and reporting obligations in Australia that it hadn't planned to have or anticipated having. We could very quickly see a situation where a permanent establishment for the Swiss business is established in Australia, which can have corporate tax reporting and payment implications. And this is more prevalent and relevant with senior executives, as I said before, because of the role that they perform. So it's really important that you think about your senior guys if they're coming back to Australia earlier than anticipated, and particularly if they're continuing to do their overseas role, but from Australia, that we look at not only the employees' exposure, but also the company's potential exposure that they wouldn't otherwise have had. So that's really the first thing that we're getting asked about extensively. To a degree, the flip side of that is, and this is quite a common question, actually we had some questions from participants before the webinar on this, relating to expats or citizens being stuck in Australia. And what I mean by that for the most part is when Australians have at the start of the pandemic thought, I'm going to go home for 2, 3, 6 months because I feel safer in Australia. I want my family to be there. I want to be close to my family in case anything happens. So they've rushed back to Australia with a view to only being here for a short period of time, and then going back to wherever they came from when they were on their assignment, be it the UK or the US or whatever it was. And this is quite a challenging one because initially the ATO said, well, if you come back for 3 months, you're still doing your overseas job, you're not working for the Australian business, and your intention is to go back to where you came from again, then we're not going to get too excited about maybe taxing you here or calling you a resident or any of those things. As time ticked on, however, particularly once we crossed over June 30 last year, the ATO said, well, now we're going to have to look in a bit more detail at individuals' facts and circumstances to make individual-based decisions as to whether someone who's come here temporarily for safety reasons has in fact become a resident and does in fact become taxable here. And what they've said in a nutshell is you have to apply the rules that applied pre-COVID to make determinations as to whether somebody who comes here for, be it 6 months or 9 months or whatever it might be, has regained their Australian residency and becomes taxable here. So in those scenarios, what we have to do is a facts and circumstances review of the individual situation to determine whether they are a resident here or not. And if they are a resident here, but they continue to work for their overseas business or entity, then we need to do a bit of analysis of the treaty between the two countries, if there is one, to see if there's a way for us to say, well, now this individual who's stuck in Australia temporarily is a resident here, but is also a resident somewhere else, and intends to go back to that place. Perhaps we can use the tax treaty to pull the taxation of that individual back to the country where they were working before they came home. That's not a straightforward thing to do, partly because individuals' facts and circumstances obviously vary from one individual to the next, as do the terms and conditions of the double tax agreements. While they're largely all similar, they're not all the same. And some countries we don't have them with at all. Hong Kong's a great example of a country where we don't have a tax treaty at all that's relevant in this case. So very much in that circumstance, as time's gone on with expats or citizens or individuals who are stuck in Australia for COVID reasons, we end up having to do a bit of a line-by-line review of their facts and circumstances to understand their taxability here. And as time goes on, it's more and more likely that they're going to be resident and taxable in Australia, and then we're going to have to unpick what that means for them from a global tax perspective and deal with any employer obligations that go along with it. So I might just move on from there, conscious of time. Sort of similar to the things we've spoken about, I'll cover these ones quite quickly. We've seen more and more individuals who were going to go on an overseas assignment. I was going to do 2 years in Singapore for my company. Actually, I'm going to do the Singapore role, but I'm going to do it from Australia because it's safer and I can stay here and it's difficult to get to Singapore. So what we've seen is companies going, well, that's fine. Hand in your laptop from the Australian business, we'll get you set up as an employee of the Singapore business. You can start doing your Singapore role, albeit you'll do it from your living room in Australia until things calm down. And while that's good from the employee's perspective and potentially good from the Singapore business perspective because they've got the employee that they need doing the things they need them to do, the challenge you have there obviously is that individual doesn't break Australian tax residency, and because they're working, performing the services in Australia, the ATO's view is that individual is taxable on the income they're earning doing that role, regardless of the factors for the overseas business. So the ATO would look at that and say, well, the salary you're earning there is taxable. We expect you to be paying tax and super and all those things on that. What's more, we expect your employer to be taking care of payroll obligations and super obligations and those things, which can lead to a circumstance where the Singapore business in my made-up example needs to register with the ATO for all of those things. The other problem that can throw up is if you were expecting to go to Singapore on a Singapore salary and pay 15% Singapore tax, now you're getting paid by the Singapore business on maybe a Singapore salary, but the tax burden is going to be 45% or whatever it turns out to be. You can find a situation where the individual has an unfortunate shock once they realize they've got the additional Australian tax burden that has a massive net impact on their position, and they're not going to be super happy about it if they haven't planned that out. So there's a whole host of things to think about when individuals are starting their foreign assignment but never becoming foreign from an Australian perspective, if you see what I mean. And again, that needs careful planning and consideration to determine whether that's viable and whether the compliance mechanisms are in place to deal with. I would say less of an issue from a tax differential perspective if the person was going to go to a high tax jurisdiction, but if the assignment was supposed to be to a lower tax jurisdiction, then we can have some real tax differential problems as well. And look, number 4 on this slide is pretty much the reverse. People starting their Australian jobs but doing it from the UK because they can't actually get to Australia. Generally a more simple proposition from the Australian perspective because the individual hasn't actually got here to become a resident, to become taxable. But all those problems I just, in number 3 that I just covered from an Australian perspective, if you just flip that situation over, the Australian business is likely to encounter those challenges in the country where the individual is sitting. So if the Australian business now has an employee working for the Australian business but sitting in the UK, there's a real risk that the Australian business becomes exposed to UK payroll withholding, national insurance, and all of those things that go along with it, that need obviously some planning and some compliance and some process and some protocol put around them to make sure that they're not missed. So those two are pretty much the inverse of each other. We're really talking about people performing their Australian roles from overseas, or performing their overseas roles from Australia, and some of the unforeseen consequences from a tax compliance perspective that we have to deal with. The last bullet point I've put on this slide is the future of mobility programs. And while the question marks look like an accident, they're not. I think there's a huge question as to what mobile workforces look like in the future. And if you're an organization that's used to having a mobility program, where you might send 10, 50, 100 expats around the world year on year to do roles, I'm sure that you and everyone else are doing thinking around what that looks like for the next 2 or 3 years, because my simple view is it's never going to be quite the same again. We're always going to see some mobility of senior people and some mobility of people to get life experience and work experience offshore, but it's going to have to be a much more planned, managed and choreographed activity, and it's likely to be much more expensive and carry much more risk with it for the time being than it ever did before. And let's be honest, mobility programs weren't simple 2 years ago. They're definitely not going to be simple going forwards. I also think that mobility programs traditionally haven't really cared about remote workers and short-term business travelers all that much. They've been less of a priority for mobility programs and expat tax and mobility managers within large organizations. All of those things now, I think, come into the remit of mobility programs and are going to make it challenging. So question marks I put there, I could talk about it all day, and I'm happy to chat to anyone that does have those challenges, but it's not something that I can give you an immediate answer to. It's going to be an evolving and interesting area, I think. So I think I've got one more slide to cover really quickly. This slide, it really is just a reminder around the challenges that existed for expat tax before COVID are still there. Residency in Australia is still not straightforward. Breaking residency is a challenge. Becoming a resident, again, has to be clearly understood as well. My sense here, and I think we may cover it later on, is that the ATO are going to start looking at questionable residency cases much more closely as time goes on, because there's going to be an imperative for the ATO to be filling the tax gap, if you like, and making sure they're collecting all the tax that they can, whereas they might not have looked at people's residency as closely in the past. I think we're going to see them swing towards looking at it closely and finding more people to be resident than they might have done in the past. So I think once COVID abates, we're going to see this become one of many focuses for the ATO. FBT, I mentioned before, our next session's on FBT, so I won't spend too much time on it. FBT is a challenge for cross-border individuals, the main reason being very few countries in the world, if any, actually have an FBT regime. So it's quite difficult to understand that the company has to pay the tax on the benefits in Australia rather than the individual. And then there's a whole question mark around creditability of tax between countries and all sorts of things in the FBT world that is a challenge. Super is the other thing that has always caught expat tax, expats and expat tax managers out. Super is a little bit different in Australia to the rest of the world. Some individuals can get out of their superannuation obligations when they come to Australia in certain circumstances. For example, if they can get a certificate of coverage because they're from a country that has that reciprocal arrangement, the US is one, but many people can't. And that becomes an unexpected burden or expense and just an additional challenge with cross-border and expat individuals. So those three things, I'm really just calling out things that were always a challenge and continue to be a challenge. And I think there will be more focus on them once, hopefully, the COVID challenge abates, because the ATO will be looking at areas where they can raise revenue that they maybe haven't focused on too much before. And with that, I've already taken up slightly more time than I said I would, so I've already put Maria and Rebecca under a little bit of pressure, for which I apologize, but I'm going to hand over to Maria to really focus in on the immigration matters from here on out.
Thank you, Ben. Good morning, or wherever you are in the world. I'm sitting at home, and obviously we're dealing with our third lockdown. May I start by first introducing myself? I'm Maria Jockel. I'm BDO's Australian leader of our corporate immigration law firm. I also lead BDO's global immigration services. BDO offers immigration services in over 94 countries in the world. I think I would be remiss if we did not start any presentation on Australia's immigration laws in the context of its complexity. Very few people understand its complexity. We know that the industry is divided between the lawyers and non-lawyer agents. Obviously, that's going to change shortly with lawyers being released from dual regulation. But those of you who are involved with immigration will know that it's a complex labyrinth of rules and policies which are highly codified. And at the end of the day, whilst there are 3,000 pages of legislation, it's underpinned by over 50,000 pages of internal policy guidelines of the Department of Home Affairs, which guides decision makers in the exercise of their powers. Those of you who are interested in how Australia continues to meet its economic needs as a nation of migrants, but also its national security and broader needs, will be watching this space and will be noting that since 2015, and even more so since December 2017, with the establishment of the Home Affairs portfolio, Australia continues to transform, and I mean transform, the management of Australia's borders during this period of lockdown, and also the closure of the borders, which are probably going to continue until 2022. We are all experiencing the consequences of ongoing restrictive reforms and a migration program, both temporary and permanent, which continues to be calibrated to meet Australia's needs. That has certain implications for meeting your workforce needs, but in our considerable experience, all the clients that come to us are able to meet their workforce and compliance needs because we are indeed Australia's leading specialist lawyers. So Australia continues to need targeted skilled migration because it is consistent with Australia's economic recovery. Don't despair that the system may be somewhat opaque and not transparent. It cannot be otherwise because, remember, the number one priority is to protect Australia and keep us safe. Number two priority is to ensure that the Commonwealth Government's economic stimulus plans come to fruition. Next slide, please. In terms of the Department of Home Affairs, over 30,000 visa applications each day in November 2017. At that time, the department predicted a 50% increase to 26-27. Indeed, as Australia is probably the safest haven in the world and indeed the most prosperous during COVID, there has been a significant increase in applications. Don't think that with the border closed that somehow or other they've abated. That is not the case. As we all know, immigration is a significant revenue earner for the Commonwealth of Australia. In this financial year, in the financial year prior to COVID, the department was budgeted to raise some $3.25 billion in visa fees, fines and levies. Those of you that do 457, 482 visas will be aware of the fact that the Skilling Australian Fund levy raises significant revenue for the Commonwealth of Australia. In contrast, in 2003, the predecessor department raised some $320 million in revenue. That tells you the constant increase and demand for temporary and permanent entry to Australia. Next slide, please. This particular slide gives you a pictorial depiction of the fact that the Home Affairs portfolio supports a federation of independent security and law enforcement agencies. Historically, we immigration lawyers were used to the old Department of Immigration. It was an administrative decision-making agency. Now, it is part of a whole of government approach, and in particular, in the context of the role of the Australian Border Force, which is the independent operational enforcement arm. They are the police force for immigration and customs. Of course, because of concerns with national security and other measures, they work closely with ASIO, the Australian Federal Police, the Australian Criminal Intelligence Commission, and of course AUSTRAC, which is responsible for the flow of money across borders, etc. We're living in a complex world, and none of us need to be persuaded about that, particularly in the experiences that we've had in the last 12 months, and has been touched upon what will be the new normal. Question mark. New slide, please. Now, this is another internal document from the department, which I obtained lawfully, by the way, and that is a pictorial depiction of the fact that the Australian Border Force are critical to the operations of the department, as is policy and regulation, as is intelligence, which is obviously the sources of information that the department, the Australian Border Force, obtain, including from other agencies such as the ATO and others, so that they can ensure regulatory compliance. Client services of the people who process visas, and behind this extraordinary labyrinth of joined up government is a complex enabling support, a digital platform whereby all the information that you ever provide to the department or to the Australian Border Force is subject to data matching on a targeted basis, because we now also have a national data matching processing centre, and that all enables the whole of government regulatory compliance model, which Ben also touched upon a bit earlier. Next slide, please. The Australian Border Force. When I first learnt of the fact that they were going to be the independent operational enforcement arm of the previous Department of Immigration, I naively, even for me at my stage of career, thought that they may focus on the border per se, and indeed these are the people that we meet at the border. But in fact, the Australian Border Force works overtly and covertly. They are the equivalent of Australian federal police officers, and indeed they have extraordinary powers under a labyrinth of legislation which relates as broadly as trade enforcement, the migration system, which is indeed an extraordinary one, border protection, which is now pivotal, border management, which we all understand. Next slide, please. And most particularly in terms of what we do on a day-to-day basis is employer sponsor monitoring and compliance, which is at the bottom of this particular slide. And what motivates it? Well, concerns in regard to visa and migration fraud, foreign worker exploitation, the concern about people smuggling, and of course the need to have a sustainable immigration policy and program, and to ensure that those people who shouldn't be here can be removed. Next slide, please. This is another photo. The one to your left is taken from an internal document of the department, which basically shows you how the Department of Immigration / Home Affairs / the Australian Border Force, the dark blue officers there are your uniformed and non-uniformed sworn officers of the Australian Border Force, as well as, of course, your other officers of the Department of Home Affairs / Immigration. You can see that they are interspersed, they work collaboratively, seamlessly, and they are an important part of keeping Australia safe, but most importantly, to ensure that we who may employ overseas workers, it doesn't matter whether they're on a 457, 482 student visa or whatever visa, if they're not Australian citizens or permanent residents or New Zealand citizens, that they are compliant with Australian laws, including visa laws, work rights, tax, superannuation, etc. As I said earlier, the Australian Border Force in their sponsor monitoring unit, which is both uniformed and non-uniformed so that they can look like you and me, have a broad range of powers. They range from education awareness to monitoring. The monitoring takes many forms: interviews, site visits, interestingly announced and unannounced, desk auditing, which is really doing it paper-based, where there's no need for you to front an Australian Border Force officer, and then of course referrals from other agencies, the ATO, Fair Work Ombudsman, the Australian Securities and Investment Commission, and others. And of course, if you lodge something with the department which enlivens particular interest, referral from the Department of Home Affairs portfolio to the Australian Border Force or the Fair Work Ombudsman, etc. Next slide, please. The Department of Home Affairs, and this is obviously in conjunction with the Australian Border Force, has a very complex and expansive compliance monitoring and sanctions regime. At the bottom of that pyramid, which is another document taken from the department some time ago in one of its presentations to stakeholder engagement people such as myself, you can see that there's always the desire to educate, to ensure that people comply, in which case, if they are subject to monitoring, the outcome is satisfactory. If the outcome is not satisfactory, well, then anything can happen, from a warning, and if you are subject to a warning, you are subject to adverse information. This seminar or webinar webinar does not permit me to address those things, but if you're interested, today is really touching on many issues that we could expand upon as part of our series of webinars which inform you and empower you to continue to meet your operational needs while ensuring in a sensible way that you are compliant. Obviously, depending on the nature of the breach and its gravity, the Department of Home Affairs has a whole plethora of sanctions that it can adopt, ranging from obviously barring you from participating in the programs, cancelling all sponsorship and the visas of your workers, and all the way up to if in fact there is an unwillingness to comply, I'll forget that word. If you're just not wanting to comply and they think that you're giving them a very, very hard time, well, you'll get the full force of law. So obviously, everyone cooperates with an agency which is here to really encourage you to comply with our laws. Next slide, please. The Australian Border Force and the Fair Work Ombudsman. I touched upon the fact that we're dealing with a whole of government approach. Think about it. There's 25 million people in Australia. We fit into the city of Beijing. We're the size of America or China. We have this extraordinary demand for temporary and permanent entry to Australia. And as one of the luckiest countries in the world, everyone wants to be here. They want to work here. No one wants to go home. They want to stay if possible. And therefore, even back in 2013, the previous Department of Immigration entered into a memorandum of understanding with the Fair Work Ombudsman. This was before we had the dedicated Australian Border Force, but this is an example of what continues in terms of the close collaboration between these two pivotal agencies that are concerned with regulatory compliance, particularly in the employment and payroll and related spaces. And so therefore, some of you may indeed be subject to Fair Work Ombudsman inspections. We've had a lot of media coverage in regard to the hospitality industry, a number of major providers who have left the industry, including Dinner by Heston Bloomfield, as a result of the unfortunate non-compliance with our complex hospitality industry awards, etc. That is a case which is an example of where both agencies, the Australian Border Force and the Fair Work Ombudsman, work jointly as a result of one complaint from one worker, and unfortunately we're aware of the consequences of that. Our job when we work with our corporate clients and discerning individuals is to enable you to meet with regulatory compliance requirements in a seamless and positive way, and if there is an inadvertent breach, to ensure that you have the best outcome in all the circumstances. Next slide, please. Home Affairs and its armoury of powers. Few appreciate that in December 2018, the Enhanced Integrity Act was passed, which gives the Minister of Home Affairs the right to publish personal information about a company or a current company or former company or employer that has employed overseas workers on the 457 or the 482 or the 494 visa programs and have failed to meet applicable sponsorship obligations. Below is a snapshot of what is taken from the department's website, an example of somebody who breached their obligations. They were subject to sanction, they were subject to an infringement notice, which is a pecuniary penalty, etc. This is the sort of publication that occurs. This is another area of law which we could touch upon if you're interested in forthcoming webinars. Next one, please. Enhanced Integrity Act and data matching with ATO. As been touched upon earlier, and what the public don't know, is that since 2008, the Department of Immigration and the ATO and indeed other government agencies have had selected data matching protocols, as a result of which the ATO and these other government agencies have been enabled to undertake the administrative and regulatory compliance activities on a targeted basis. Most relevantly, with the passing of the Enhanced Integrity Act, the ATO provides to the Department of Home Affairs everyone's tax file numbers. So they are now aware of everyone who's working, even those who shouldn't be, who are, for example, on visitor visas or on student visas, who may be working in breach of their work rights conditions. This is obviously an important adjunct to maintaining the integrity of Australia's tax, visa and related systems, and of course it enhances community confidence in the integrity of those systems. The data in regard to whatever we lodge in regard to 457, 482 nomination and visa applications is basically there to be trawled through, targeted, and to detect compliance, not only in regard to the visa holders, who may be your employees and yourselves if you are the employer or the sponsor, but also those that they broadly refer to as migration agents, which also includes us who are accredited specialists and leaders in our fields in this complex jurisdiction of law. Move on to the next slide, please. I think this is a nice little pictorial way to say that enhanced integrity and data matching with the ATO is really a wonderful way for you to reflect on your due diligence and what are you doing to connect the dots. How are you linking with people like Ben and Rebecca and I so that you maintain tax return integrity, that your income tax, your superannuation and other compliance issues are met? Because if you can do this seamless approach, and it's just common sense in this complex world of ours, that you will therefore be always compliant and you will not be obviously privy to fraud, because why would anyone want to be involved with anything of that nature? In this 21st century, it's remarkable how much of the intelligence and the compliance activities of, for example, the Australian Border Force is in fact as a result of third-party dob-ins, including 40% from people known to you, internal to you. So that's an incredible statistic. Move on, please, Rebecca. So data is enhanced periodically or exchanged periodically. It's been going on since 2008. Relevantly, and this comes from the ATO itself, between 2017 to 2020 financial years, the ATO expected that with the record of data that they obtained, including from the Department of Home Affairs, it was likely to exceed 20 million individuals. Do your maths. There's not that many taxpayers in Australia in terms of citizens, and so therefore a lot of these others must be people who are on some form of temporary visa with or without work rights. Move on, please. Enhanced Integrity Act. We all know about single touch payroll reporting. I would urge you to review your payroll reporting. Ben Renshaw does quite a bit of compliance work to ensure that payroll compliance is in fact as it ought to be. It's better for you to do your reviews at your own instigation than to be requested to consider your compliance once you get a Fair Work Ombudsman or an Australian Border Force, or if you're doubly lucky, a joint compliance activity from both agencies, because with that single touch payroll and indeed data matching generally, there is now a ready capacity by this agency to identify and target areas of anomalies, and it doesn't have to be non-compliance, an anomaly or non-compliance, and we all know that from the 1st of July 2020, most businesses have to comply with the single touch payroll rules. We as immigration lawyers take account of all of these things when we deal with our corporates and our individual clients, and that's why we pride ourselves on the fact that our clients are compliant. Should they be unlucky enough to have an inadvertent breach, that we can manage this space very effectively. And I'm proud to say that we've worked very collaboratively as a law firm with Ben Renshaw and his team and other people at BDO. Next slide, please. Australian Border Force travel exemptions. We all know that Australia's borders closed, and even we Australians have to get the permission of the Commissioner of the Australian Border Force, who coincidentally has the same standing as the Chief of the Australian Defence Forces. He or his delegate determine whether we Australians can depart Australia. Similarly, the Commissioner, in accordance with his Commissioner guidelines, which change from time to time, determines whether an inwards travel exemption in respect of a non-citizen, which includes New Zealanders, whether that travel exemption should be approved, regardless of the basis upon which a travel exemption is approved, whether you're an Australian citizen or you're an overseas arrival who is not a citizen. Everyone must comply with mandatory 14-day quarantine, and there are ancillary requirements in terms of the proof of negative COVID PCR test within 72 days prior to scheduled departure from Australia. We all know that there is a national cabinet and that the Prime Minister is periodically announcing the health and related measures being undertaken on a national basis, including in regard to the capping of international flights, which continue to limit the number of travellers to Australia. This is a dynamic space. It requires expertise. Again, proudly can I say we have an exceptional, and I mean exceptional, number of applications approved, because we understand the nuances of what's involved and we work selectively with the right clients to ensure the best outcomes. Next slide, please. So this is a continuation of the Australian Border Force. We know that no one will get their visa approved. You can lodge visas. There's nothing to stop you lodging visas. Remember, you're raising revenue for the Commonwealth of Australia, and there are thousands of them being lodged even while the borders are closed. And many agents are advising to lodge visas, but that doesn't mean that they will be approved. So think about what you're doing. And then if the person is offshore, say, well, hang on, what do I need to do to get an associated travel exemption granted? And before you even embark on that space, get expert, credible, honest, fearless advice, which will tell you whether it's doable, so you're not wasting your money to begin with. But in any event, those visa holders, we've got lots of visa holders who want to depart Australia. However, they can't return unless they get a travel exemption. We're dealing with a global client at the moment with a really highly credentialed person with incredible skills who holds a German passport, went home for his mother's funeral. They've come to us when after going to somebody else 3 or 4 times, asking us to help them with getting this person back to Australia. Of course he should be able to come back to Australia, but you've got to know how to present it. This is an art. It is also a complex, discretionary, legalistic process. And people just keep on lodging travel exemptions ad nauseum, thinking that if they keep on doing it, next time they'll win Tats Lotto. It doesn't work that way. So if you're a temporary visa holder, you've got a current visa, you want to leave Australia, please think about how you're going to be able to either get an inwards travel exemption. In rare cases, we get them actually approved even before the person departs so that they know they can readily come back. But in other cases, you do it after the temporary visa holder departs, and then you ensure that the nature and extent of the documents and the way that the 1,000 characters, which is all that is permitted for a travel exemption application, are presented very succinct, legal summary of the key aspects of why your client should be granted a discretionary travel exemption are indeed approved. So please consider what you're doing, whether you're a private individual or a corporate. Everything is doable if you come to people such as us who are indeed preeminent experts. Next slide, please. Visas overview. Given the complexities of our visas, and I'd be very pleased if you could indicate your interest, we're proposing to run a series of webinars in regard to the 482 visa program, which those of you who work in this jurisdiction will know is the more restrictive version of the previous 457 visa. I actually wrote Australia's only textbook on 457 visas, which I'm very grateful. In the preface, I acknowledged the cooperation of the department in the preparation of that text, which is now superseded and indeed sold out. We clearly know what we're doing, and we're well able to assist you with your global mobility needs. Now, of course, everybody wants permanent residency. And there's about 137,000 482, 457 visa holders currently in Australia, but only 22,000 186 visas can be approved in this financial year, a 26.7% drop on last year, again part of the restrictive reforms that the government continues to implement. Again, we can provide you with a webinar which honestly provides you with a summary overview on aspects of the 186 visa program. Let me proudly say that we don't have our visas refused, but then we're selective as to who we want to act for. We only progress matters if we feel that there is really a credible and strong case to be made and that there is appropriate documentary evidence in accordance with the requirements of this strictly legalistic process. Next slide, please. What does this mean for you and your business? Well, of course, you need to meet your operational needs, whether you use overseas students, working holiday makers, the people on the 482 visa program, or anyone else. Australia is a nation of migrants, and we depend on overseas workers as part of our population growth. At the moment, we will have zero population growth because we've had a 97.8% drop in arrivals relative to, I think it was about May of this year. So clearly, the closure of the borders is having a phenomenal and dynamic impact on Australian businesses. But it's not all bad news. Any of you who watch this space will know that the Australian government, the Department of Home Affairs, continues to allow credible Australian businesses to meet Australia's workforce needs. They are targeted. We have the priority skilled migration occupations in a list. We have priority processing guidelines. We know which ones will get through and why. Please feel free to come to us if we can give you credible, honest advice based on the facts of the individual case. Of course, Australia will continue to welcome foreign workers. It must. The program that was announced in October 2020 is simply recalibrated to focus on the highest skills. That includes the Global Talent Program, it includes the Business and Investment Program, and it includes the Select 186 program. The 482 visa program is demand driven. It depends on the economic circumstances. And let me tell you that the department actually monitors how many applications are approved, in what classification, by what employer, what passports, in what industry sector. And if they think that there's too many, for example, applications being done in one particular occupational classification, they may tighten the requirements for that occupation. It will not necessarily be as transparent as you would like it. We know about the significant powers and reach of the department, the Australian Border Force, and of course we've touched upon other agencies, including the Fair Work Ombudsman, ATO, etc. All of you, whether you're in finance, human resources, wherever you are, whether you're the individual visa holder, would-be visa holder, or the family member of somebody, please understand that from our perspective, our job is to represent our clients' interests, to inform them, to empower them. But those of you who are boards, members of boards, directors, senior managers and shareholders need to be aware of the naming and shaming provisions. That's the Enhanced Integrity Act. Their powers, the financial loss, reputational and brand damage this can cause. Digitalisation, which we know is now the mainstay of Australia's economic prosperity. We're punching above our weight. We're doing incredibly well despite a trade deficit of 197 billion odd compared to the rest of the world. We will continue to thrive and prosper, but understand that what you're doing needs a considered approach. You need to think about what you're doing. It's not just quickly filling in a form and popping it onto an online system and think, oh, you know, she'll be right. There is data matching. You don't know when that data will be matched. I don't know when it will be matched. Ben doesn't. Neither does Rebecca. And then there's the whole of government approach. And that impacts on each and every one of us. Me individually in terms of tax, my super, etc. But overall, all businesses, including, as Ben has touched upon, a payroll tax, superannuation and regulatory compliance. The message is continue on, meet your operational and business needs, but empower yourself to be informed, because when I used to work in government as a young woman, the first thing I learned was information is power. Next slide, please. Conclusion. Well, fortunately, because our laws are the most complex and dynamic in the world, after 250 years of immigration, we only have 25 million people, if you're not a person who's pro a big Australia. Unfortunately, this complexity also means that we all have to sharpen our pencils to become better at what we do, to ensure that you can meet your needs, whatever they may be, whether it's in the context of global mobility or otherwise. Ongoing reforms will include digitalisation of the visa system. Virtually every visa that we lodge is now only lodgeable digitally. The 482 program will continue to address Australia's economic recovery plan. It will continue to meet targeted skilled workforce needs. As I said, we are specialists in what we do. Look up our profiles. We are industry leaders, and I'm very pleased to say that BDO Migration Services, an incorporated law firm which offers client confidentiality, legal professional privilege, and par excellence client service delivery, works collaboratively across all BDO service lines, and in particular with Ben's team, which is of course people advisory. We provide a holistic, seamless and integrated global mobility service while protecting your brand. Next slide, please. Now I'm going to introduce you to Rebecca Thompson, who I hold in very high regard. She's our Managing Associate, and she's going to touch upon a number of what we call value adds. We believe at BDO Migration Services and BDO that we're more than just a visa service. We're here to provide you with a whole plethora of related services which will empower you to meet your business and operational needs. Whatever they are, we are truly a one-stop shop. Please go ahead, Rebecca.
Thank you, everyone. So I guess what you've received is quite a broad overview of your risk and compliance. Certainly Ben touched on payroll, superannuation, things that you need to consider when you're employing foreign workers in Australia. And so really the message that we have is the importance of undertaking the due diligence that you have when you're employing overseas workers, payroll, superannuation, your sponsorship obligations, but also to think about building out those mobility programs to meet your operational and compliance needs. As Ben touched upon, often those programs may not have touched every sort of worker you might be bringing in, and it's important now for businesses to consider across the board what the risks, where their exposures might be. Also, as you move into forward planning, consider the need for business travel and international assignments. What is it that you need? What does your business need to put in place to meet the next normal? So, you know, there's talk now, it isn't the new normal because the normal will continue to change as we move through the COVID pandemic. But what is it that you need? And really the importance of planning in advance. Who do you need? When do you need them? And why do you need them? As Maria touched upon, travel exemption applications, you have to have a good business case to put them forward. You need to really consider some of the options. You need to plan in advance. There's certainly nothing that can't be achieved with the right information. So we really consider that it's an across-organisation approach to managing risk. It's not simply the people that are in HR. There are a whole range of steps that you can institute as an organisation to ensure that you meet the requirements across the board, whether or not it be payroll, whether or not it be visa and related services. So some of the things that you should really consider is what training are you offering to staff around managing a mobile workforce, the mobility life cycle, not leaving it to the last minute, understanding expatriate compensation, what are your cross-border legalities, things as simple as employing student visa holders. In HR and P&C, you might know exactly what the work limitations are, but ultimately when it comes to the people on the floor who are rostering them for their work, do they really understand what a fortnight is? Do they understand what that 40-hour limitation means? What are the labour market testing requirements? Maria touched briefly on the complexity under the 482 program. There is a lot of refusals as a result of the 1 October labour market testing changes. Really, do the people in recruitment know what they need to know? And what are your sponsorship obligations? So, for example, as Maria touched upon, at BDO, we really believe that it's important to partner with companies and businesses and individuals to meet all of their operational needs. So, for example, we have our BDO Learning Academy that provides a range of training that you can roll out to your employees so that you can ensure that they understand what managing risk is in this space. Again, in the same area, a global mobility checklist is available, and it goes through a range of what might be your potential exposures, where you might need to look at, not just in employing foreign workers, but in payroll, in data security, because there are broad-ranging issues that are incredibly important for you to consider as a business. So that's something that we've worked on, and you can readily access, and certainly reach out to us if you would like to do that. I touched briefly on student visa holders. I won't go into detail, but it's incredibly important as the department focuses, as data matching goes ahead. You have, for example, student visa holder employees. Do you know what their work rights are? Is your business actively checking work rights? On the left, you'll see the department screen, or utilising, for example, BDO has a work rights check program that you can send an inquiry to us, and we'll come back and provide you with information about what are the risks, what is it that you need to know about employing that student visa holder or any other visa holder. It's important that the right people in your business know how to check this information. Maria touched again on improved sponsors and the requirement to meet your sponsorship obligations. The Australian Border Force is working hand in hand with the Fair Work Ombudsman. They're doing site visits. They undertake audits. They undertake both Fair Work Ombudsman audits and Australian Border Force audits. So again, if it's of interest to you to look at auditing and looking at your business and the records that you're keeping, please reach out to us and we can certainly provide you with more information. So that was just a very quick flyover, and I'm going to hand over about any questions that people might have.
Very good. Thank you, Maria. Thank you, Rebecca. That was fantastic. I'm sure everyone realises there's a huge amount of content there that, as you've said, we will be more than happy to drill down into more detail, and we'll put a survey out after this to understand what people want to hear more on. But we recognise there's a whole host of things we've discussed, and it's impossible in this time frame to cover them all in detail. We have had a couple of questions, however, so I might read those out and have Maria or Rebecca sort of deal with them reasonably quickly. I think I've got a few to go through. So the first one relates to, I'll just read it out. What is the ongoing impact of COVID restrictions on those in Australia on temporary visas? And is there likely to be an impact on their ability to attain PR? So Maria, I think that's a question for you.
Yep, thank you. Few people know that there's about 2 million temporary visa holders currently in Australia. About 135,457,482,494 visa holders, working holiday makers, that's the 417. There's about 540,000 international students, etc. Quite a lot of people on visitor visas, etc. So there's a lot of people who have remained in Australia despite the closure of the borders and the urging by the government for them to depart if they don't have a valid reason or a lawful visa which permits them to stay, or bridging visa. In that context, obviously, we're finding an increasing number of 45748 visa holders are asking their employers to sponsor them for the 186 permanent residency visa. That's just understandable. Clearly, we're well able to assist our clients in this regard, but the demand is, as I've touched upon with some of the data which I've shared with you today, which is not in the public domain, the demand is quite exceptional, and we would always urge clients to get proper advice based on the individual facts of the case, because yes, the department is granting 482 visas. They are slow unless it's a priority occupation. We're finding that our 186 visas, the permanent residency ones, are indeed surprisingly being approved very quickly. But then I think that's probably reflective of the way that we work and the way that we empower the department to make ready decisions on a decision-ready basis. So don't despair, Ben. I would urge everybody to make inquiries, see what can be done, and in that way, you'll get the best advice and ensure that whatever you're doing, it's got the best chance of actually meeting whatever the aim is.
Perfect.
And
thank you.
Further to Maria's point, there's been some concessional arrangements that have been introduced by the department that have amended some transitional arrangements that were already there. So if employees on 482s have been stood down or had reduced hours, at the moment, that's not impacting on their eligibility for 186s, but there's a range of considerations in that regard. So individual advice is warranted, but there's a range of concessions that have been introduced to respond to the COVID crisis.
That's excellent, thank you. I've got another question for both of you that's come through. It's a little bit of a crystal ball question, but we'll have a go at it anyway. The question is, what's the expectation around the Australian government's immigration policy post-COVID? Do we expect to see them try to boost numbers to make it easier perhaps for people to get in, or do we think that restrictions are going to remain in place and actually we'll see reduced numbers for a while to come? So good luck with that one.
Can I say that we track global immigration trends, including in Canada, US, the UK, etc. For example, Canada's adopted a more liberal policy at this point in time to attract more migrants, but there's a very select small program. Australia, conversely, continues to maintain its closed borders. And obviously, with the closed borders, the focus is for the indefinite future, as I said earlier, to maintain health and safety whilst having a carefully supported and vigorous economic recovery plan. We know that the government's put a lot of money into economic stimulus. The government has identified critical industries that it sees are going to aid Australia in its economic recovery. The government has also created a new occupation list, which is called the Priority Skilled Migration Occupation List, which changes from time to time in regard to key occupations which they consider there are targeted skill shortages and Australia needs. The department is also calibrating its response by deciding which visa applications, including in the 482 visa, will have lengthier processing delays, many cases well above 5 months or more. So the department has an enormous armoury and plethora of powers and policy settings that it can take account of in terms of how it manages Australia's migration program. As somebody who's been passionate about this jurisdiction, and I'm very privileged to say highly networked with government, and a perpetual student of where government's going with law and policy, my sense is this: what happens in the future really depends on how quickly Australia recovers from the current pandemic. Some people are saying that the pandemic may indeed take up to 6 years to pan out. I think that one epidemiologist is saying that we need to vaccinate most of the world in order to stymie this pandemic. I'm not in that league. I'm not able to comment, but clearly there are complex considerations which are taken into account, and it is a whole of government approach. We appreciate the Minister Dutton is a key member of the Cabinet. We have the National Cabinet, we have the Prime Minister, we have Foreign Affairs, we have DFAT, we have a lot of other inputs. So these are all the things that go into the mix and determine what the government does next. If you go back in terms of what happened back in October 2020, the Minister of Immigration, in conjunction with the Minister for Employment and Workplace Relations, agreed that they would develop a targeted list of occupations which are in short supply. That's the priority occupations list that I mentioned earlier. The Minister with that issued a ministerial direction for fast-track processing, and that meant also that the visa, if the person was offshore, as well as the travel exemption applications, could be facilitated on a targeted basis. They implemented the third type of labour market testing, which includes on Job Active, which is a Department of Employment website. That website enables the Commonwealth of Australia to get data, real-time data, as who's advertising what positions when. All of that data will be considered. There is a lot of other inputs that the government has, etc. But let's say hypothetically that something happens so that Australia suddenly experiences a boom, and assuming that COVID is far less contagious and there are lesser safety concerns than we've known so far, then you will find a liberalisation of the policy setting. The more restrictive aspects of the migration programs in their various aspects will be fine-tuned, and there may be indeed further wholesale reforms. Remember, the 457, 482 visa programs were always demand driven. And in the days of boom, you could bring in thousands of workers. We all lived through that. Now it's more restrictive, but remember, they're getting well over 30,000 visa applications each day worldwide. And there's 99 visa categories. Most of them never get you anywhere. But moving forward, I think with the best advice, a bit of planning, like Rebecca said, workforce planning, empowering your people to know what you need to do, making sure that you tick the boxes, do a bit of a due diligence, work out what you need, and then get credible advice. Okay, we're likely to need X. How do we achieve that? And then we can guide you through that process. And it doesn't matter whether it's a small client, a big client, one person or multiple persons. We're here to assist. So I can't answer for the Minister or the Commonwealth of Australia, but having been involved with stakeholder engagement, first starting with my stint in government when I worked with a Prime Minister, Premier, Ministers of Immigration and Attorney General, and that was back in the 80s when I was a much younger person than I am now, right through to now. I can tell you, watch this space. Australia will continue to grow and prosper, and they know that they need select targeted migration. So be amongst those that get your people through the system.
Perfect. I think that's as comprehensive an answer as we could possibly give on the question without having an actual crystal ball to look into. So now I'm going to cover up a couple of tax-related questions that have come through. So one of the questions we've had, and I'll read it out, we have expats who have been in Australia for extended periods due to COVID. I understand there are potential concessions from ATO regarding residents, meaning they may still be considered non-residents. What will that mean for employer obligations to remit PAYG, withholding, super, payroll tax, FBT, particularly on foreign benefits and payments? Will they similarly be exempt from Australian reporting obligations? So the answer there really, unfortunately, is a maybe. There absolutely are some concessional views that the ATO have taken with respect to individuals being stuck for a short, defined period of time where they have a clear intention to leave again and continue to work overseas, and intend to go and continue working overseas once they are able to leave. The ATO have said that they will treat those sorts of cases kindly. However, the longer people are stuck here and the longer this has gone on for, the ATO have sort of said, well, now we sort of have to look at this on a case-by-case basis and really understand the mechanics of the individual circumstance to determine whether we can apply those concessions. That being said, if you do get to a point where you have individuals who aren't taxable here, either because of those concessions or under treaty, then typically what happens is your withholding, your payroll tax, your fringe benefits tax obligations follow that tax obligation. So if the tax obligation falls away, all those other obligations do as well. The only one that's a bit of an uncomfortable exception to that is superannuation, because the rules don't clearly get you out of superannuation, certainly under the treaty, not because they actively address it, more because it's never been clearly addressed, and probably the superannuation still exists in a lot of circumstances. Now, there are other routes out of superannuation as well. So that's the one that once you're really clear with the residency and the taxability of the individual, you can tick off FBT, payroll tax, those things pretty quickly. Super sometimes requires a bit more of a look to determine whether you've still got a technical obligation for super, even if all those other ones have fallen away. And then there's perhaps a practical conversation to be had about how best you deal with that or cope with it. And that question comes up quite frequently. And actually, even before COVID, when people were relying on treaties to exempt individuals from tax, that super question could be problematic even then. So happy to get into specifics. I can't see the individuals that have asked the questions at the moment, but we will have that data. I'm happy to get into specifics. Likewise, an individual has indicated that they're stuck in Australia at the moment, as we've talked about. Where do they go to get advice on tax liability? And it's the same answer. You really, there's a couple of options. Obviously, we're more than happy to help with providing that advice. Our contact details will be, my contact details and the team's contact details will be sent out after this presentation. So we're more than happy to get involved in those things. There are obviously there is an opportunity, and people do frequently take this up, to phone the ATO directly and have a conversation with them. While that's a good option for a lot of people, I would say that the advice that you sometimes get there is a little bit dependent on the person you speak to on the other end of the phone. And often what we find with the ATO, with anyone, If it's not written, then it's of limited value, right? So ideally, if there's a question mark, you want to go down a path that gets you some written advice that you can then subsequently rely on and hold up and say, I've got advice on this issue. So while a phone call to the ATO might be helpful in pointing you in direction, it doesn't always get you to the final answer. There is a process where you can approach the ATO for what's called a private binding ruling. And in that sort of circumstance, what you do is you say, well, these are my facts and circumstances. This is how I understand the legislation to be. It's not entirely clear, however, how this legislation, how these rules apply to my facts and circumstances. ATO, can you give me a ruling that's specific to my situation? And what the ATO will do, they'll look at your facts and circumstances, they'll apply the rules, they'll look at where they've given rulings before, what the precedent might be, and they will say, in your circumstance, we think the answer is this. And the clue's sort of in the name. It's private, it relates to you, it's binding in that once they've given that ruling, you're sort of bound to follow it. And then you have a fixed answer. What I would say about that binding piece is it's binding in the context of the facts and circumstances you presented to the ATO. So if those facts and circumstances change, then the ruling that you've got isn't necessarily valid anymore, because it's only valid for the circumstances you present. So my view is the first answer has come to us, and we're happy to help. If it is genuinely grey and there's no clear guidance, then we can approach the ATO for a ruling and deal with it that way. I'd say 90% of these cases we're able to unpick. The 10%, which are often the most interesting ones, actually are the ones that we have to sort of work with the ATO to get the answer, because no one's ever asked the question before, but we can work our way through that. Now with that, we've run out of questions that have been asked immediately, so I'll just cover a couple of things off to wrap us up. The first is, and I mentioned it a couple of times, this is the first in our webinar series. We anticipate doing the next one on fringe benefits tax on the 16th of March or thereabouts, and we'll send more communication out around that shortly. Obviously, we're getting towards the end of the FBT year, so it's quite a topical session, and we run that session standalone each year, and it normally goes pretty well. So we'll be running that. Subsequent to that, we'll be running further sessions. There will certainly be another immigration and expat tax and mobility session. We're going to run a more detailed session on pay compliance, which is really around whether employees are being paid appropriately against award and EBAs, and with consideration to how Fair Work are looking at those things and national employment standards and all those sorts of things. We'll be running a session on REM and reward, share plans, equity, senior executive REM, broad-based REM, building share plans, all of those sorts of things at some stage. So there'll be a whole series of events that we're going to run. After this, we'll send out, and I mentioned this a couple of times now, we'll send out a bit of a questionnaire for feedback. And I'd particularly like to hear questions that you have about the content here, any areas that you'd like us to delve more deeply into, and also any other areas that we haven't mentioned today that you think would be helpful for us to present to you guys on, so that in a similar way to what you have today, because we're more than happy to flex our approach as we go. And I think really that just leaves me to say thank you to Maria, thank you to Rebecca, and thank you to the people behind the scenes who have helped us organise this. It's not the most stress-free activity, particularly when we're all locked down like this. And so we seem to have got through it reasonably well. And thank you to the participants who have come along, hopefully learned something, hopefully it's provoked some questions. And we look forward to presenting to you and hearing from you in the future.
Thank you, Ben, and thank you, Rebecca. And please reach out to us.
Thanks, everyone.
Thank you all.